This is the examination of the hidden human condition.
This is the Hidden Killers podcast with Tony Brueski.
We're talking with defense attorney Bob Motta right now. He's also host of the podcast Defense Diaries. Go and check that out. I'm talking about Brian Kohberger. This is something that, you look at it from one perspective, makes total sense, and another, maybe not so much, from a perspective of let's not make this a appellate issue down the road. Is this a reasonable motion for them to request all of the information, the identities, everything of how any piece of his DNA was handled, including the genetic DNA, through the whole process? Is that something that the defense of Kohberger rightfully should have access to and have a chance to go over, considering he is fighting for his life?
Yeah, I think it is. Now, obviously, I'm a defense attorney, so I'm a bit biased in that. And I've been, in these battles with the state for 20 plus years in terms of what they're going to turn over and what they're not going to turn over. The biggest thing with the state's argument is that they're not using it because they now have his buccal swab and they have his profile, his being Kohberger. So, they're saying we're not going to even introduce that at trial. Why do you need it? And the answer to that is twofold. And we'd need an entire episode, which I know we don't have right now, in terms of the IgG stuff. And I've been making the argument on my Twitter, which people should follow, defense_diaries, which is, I'm very active on there.
Sure.
But there's an argument to be made because we're talking about third parties here. Okay. So we're talking about with IgG, with the genealogical DNA, you're talking about this family tree being built from a profile. And that's how they're getting to all these offenders. It's an incredible resource and tool for law enforcement. I would say it's probably the most powerful tool in their tool belt currently. Like in terms of being able to close cold cases, I mean, we're seeing it every day.
Yeah,
we're seeing the incredible results that we're getting from that, where they're making these connections. They're able to identify missing people that have been missing for decades. It's an incredible technology, and it's a blend of technology and research, really. And the argument from Kohberger's side of this is that they need to see what they did in terms of the searching, because there is certainly the ability for Ann Taylor to go in and say, look, this was a violation of his Fourth Amendment right, because we believe that he does have a privacy interest in a third party's, which sounds bizarre on its face. Like people will probably be like, "But this guy's crazy." But because you're talking about the Fourth Amendment, we have a privacy interest, and when you try to put forward the concept that, look, we may have a privacy interest in a third party's DNA because of the fact that it's shared. That's the thing. My YSTR is shared with my father and my grandfather and my great-grandfather and everyone on the male line all the way down. So there's an argument to be made. And all I'm asking for is generally there's got to be rules. This is going to get litigated. People dismissing it as, oh, that's great. It is going to get litigated when it becomes the number one tool for law enforcement, and it's going to be used, and it's going to come up in case after case after case after case. It's going to have to go all the way up to the Supreme Court, and they're going to have to rule whether or not they should have gotten a warrant in order to do the searches that they did. Because at this point, we don't know. We don't know. This is what they're asking for. They want to know what databases they searched, because there's private databases such as Ancestry, 23andMe, and then you've got the law enforcement has CODIS. They have their databases. There's tons of databases, and some of them are private, and some of them aren't. The privates are where people can opt in. If you were to turn in your profile and you said, hey, yeah, I'm going to opt in. I'm going to allow law enforcement the ability to be able to use mine to help solve cases, then you're good to go. If people aren't opting in and they're using it, there's that privacy interest is real. And it's because of this, this just super interesting fact that DNA is shared. You know what I'm saying? It's typically people were making a comparison of the cell phone issue. Once you turn over your data, once I text, they're saying you're turning over your data to a third party. You no longer have a interest in the privacy of what you've sent. It's done. Okay, so that's different though. because you're doing that voluntarily. With this, it's not, because of the fact that we have shared DNA with our relatives. And I know there's people going to be out there, well, don't commit crimes, don't kill people. Yeah, that's not the issue. We have to take it for what the reality is. People do kill people. We have a constitution that we have to abide by. We have to have everything fit within the framework of what's reasonable under the Fourth Amendment. And this thing is a big deal. I think that the judge is going to grant some of it piecemeal, and I think he's going to deny some of it piecemeal. I don't think they necessarily need to know the names of the individuals. I don't see how that's relevant. I think that they need to know the process, they being Ann Taylor and the defendant. I think that they need to know what they did. They need to know if they went through private databases, it's going to be an issue. Yeah. It just is. Like if that's the case, Ann Taylor is unequivocally going to be filing a motion to suppress. Sure. So I mean, or try to dismiss the indictment, because the way that this works is like, I kept trying to tell people, like, take the sheath with the DNA out of that probable cause affidavit. Okay. Like, theoretically, if you can do it, like, take it out of your mind, which is impossible because we all know it exists there, but pretend for the purposes of a probable cause affidavit for an arrest warrant, take that piece out. And you're basically left with just a guy driving around. Yeah. You know what I'm saying? And like, and mere presence is not enough under the law. Like, just being around an area is not enough to charge somebody with first degree murder 4 times over, man. So it's like, and obviously I know, but that's what makes that sheath so important, because it's the link to the inside of the house. Otherwise, we have phone pings. We have him, in the area. Is it suspicious? Certainly. But does it rise to the level where they're going to be able to charge her? It's a question for a judge to answer. You know what I mean? But in my estimation, it's a much weaker probable cause argument if you're going in with just that he was around in the area. Sure. And that's not even taking into consideration the fact that they're going to be challenging all the phone pings and the GPS data, and all that stuff's going to be getting big. That's what we have trials for. Sure. That's, it's like, I know everyone wants to convict him, and I know that there's people out there who say he's innocent. Both sides just need to take a beat, and we need to wait for trial, because at this point we don't know anything about the evidence. Yeah. We know the state's theory in terms of what they think happened, and we have not had any of the evidence vetted. It's that simple. Like when I first read the PCM, I'm like, wow, it really heavily leans towards guilt. Assuming that everything in it is true, and that's the key to the equation. Assuming that it's true. At this point, we don't know that it is, because it has not been vetted at trial. That's the whole purpose of trial. Like, that's all I'm ever telling people to do. I'm like, everyone can always form an opinion. It's our right as human beings to form an opinion as to innocence or guilt. I don't think that that's necessarily destroying the presumption of innocence for people to have that opinion. All I'm asking people to do is don't have a final opinion until after we've had a trial, after the evidence has been vetted. Because that's the only time we can know. Otherwise, we're all just guessing, especially in a case like this where they're not telling us what the evidence is.
This is an examination of the hidden human condition.
This is the Hidden Killers Podcast
with Tony Brueski.